I'm Julie Barkey with this Set It update. The legislation that sets policy for Minnesota's courts, corrections, and other public safety agencies was debated on the Senate floor on Thursday. Senator Ron Latz carried the omnibus judiciary policy bill. Now, among its many provisions was the restoration of voting rights to convicted felons when their sentence is over. Senator Warren Limmer had some questions about that provision in committee, and on Thursday, he tried to remove it from the legislation.
Thank you, Madam President. Members, as you look at the 825 amendment, this goes back to our discussion regarding felon voting. We had a pretty good discussion. We had rather a robust discussion, thanks to Senator Newman, but we failed to address one major issue, and that was whether or not this provision should stay in this bill in its current form. This proposal is to remove felon voting from the bill. It's unfortunate that this election provision is in a judiciary bill, but it was the will of the Judiciary Committee to place it there. And I was a part of that discussion in the Judiciary Committee. And at the very same time, Madam Chair, we had an interesting conversation. We had all sorts of proponents. We had all sorts of people wanting for us to consider felon voting. It would have been an interesting vote if victims were a part of the discussion. It would be interesting to know whether or not someone who is denied their father or their mother, and that the income to that family was severely curtailed, and that upon the release, a probationary release of an inmate in one of our correction facilities, what a victim would say, what a son or a daughter watching their mother or father struggle to make an income to feed their children for maybe perhaps 10 to 15 years. We didn't get that very important part of the conversation or the balance of that discussion. And that's rather unfortunate. We've talked about people who should be given a chance to affirm a pro-social activity, but it's only referred to as the former inmate of a correction facility. So, Madam Chair and members, I'd like to have this discussion on behalf of the victims of the state of Minnesota that have in some ways have suffered terrible loss, and put a little bit more balance to this. You know, in our chapter 609, that's our criminal justice chapter. And I hope that you're familiar with chapter 609. Chapter 609 has a number of different criminal statutes that are referred there. And I think in order to fully appreciate what we may do or not do, I think we need to know what the victims have suffered in the state of Minnesota in order to consider whether or not we give felons the right to vote. I believe that the right to vote, or the denial of a voting privilege, let's call it a right for now, but it is a conditional right. We've had some discussion about whether or not it was included in our original Constitution. It was. 14th Amendment says that it makes reference to voting, but it also makes reference that it can be denied based on rebellion or the conviction of a crime. The conviction of a crime is allowed to be denied a vote in the United States, but the federal government and that same Constitution allows the states to make the rules on how that is applied. Well, let's take a little introduction to the victims of what they may have suffered in recent years, and we'll just follow along on chapter 609. Of course, we have murder, criminal vehicular homicide, a variety of assaults, domestic assault, female mutilation, great bodily harm caused by distribution of drugs, crimes against vulnerable adults, financial exploitation of vulnerable adults, aggravated robbery, kidnapping, abductions, murder of unborn children in the first degree, labor trafficking, unlawful conduct with respect to documents in furtherance of labor or sex trafficking, criminal sexual conduct of a child, prostitution, sex trafficking, solicitation of children to engage in sexual conduct, incest, malicious punishment of a child. It goes on and on. I think you're getting the picture that individuals who have committed crimes and been found guilty and convicted should receive a punishment when they victimize our innocent constituents. Now, I hope you're thinking about this when we're considering this bill to give felons the right to vote, even though their entire sentence is not fully commuted. You have to understand that there's an incarceration time and a prison sentence, and in most cases, there's a probationary phase to that as well. The entire process of those two ways we handle inmates and those who have been convicted of criminal crime is part of the entire sentence. And we now have a proposal before us to only recognize half of that sentence, and the other half would not be a restriction for voting. Now, I happen to believe that I do believe in a concept called redemption. But redemption comes from the action of an individual, not the action of the state. I believe that one has to prove themselves. I wish Senator Newman's proposal would have passed, that at least for a mere 2 years you had to show that you were not going to go back to a life of crime. We're taking a risk, ladies and gentlemen, by simply saying the very time that inmate takes one step out of a correction facility, out of incarceration, they now have earned the right to vote. I don't think they have. And quite honestly, I really, truly wish that victims would have been at the Judiciary Committee hearing that day. I don't know if they were invited. I suppose we were just relying on them to see some blog or some email or something that tells people of what they're doing at the Capitol in the Judiciary Committee that particular day or morning. But apparently some people have more important things to do than see us legislate. You know, the crimes are just in many ways indescribable. It kind of makes you ill when you look through the criminal code and see that human beings can actually conduct this type of activity against other human beings that might very well be unaware, completely innocent, and yet at the very same time so drastically hurt. Not just one who might be the victim, but the victim's family and extended family. It ripples through an entire small community as well as a large one. We all know that. We represent those people, those communities of 75 to 85,000 people that we represent. But we need to keep them in mind when we consider allowing an allowance for a civil right to be restored to a person who is convicted of a crime, whether it's heinous crime or not. And I hope you understand that this was not done in the Judiciary Committee. I suppose everyone has a right to come there, but they did not. I did make mention earlier that in our Constitution, not only the original Constitution, but the 14th Amendment does allow a disqualification for anyone who participates in rebellion or other crime. And so that certainly would fit where most states historically have recognized that one disqualification, that if that did happen, they do deny the right to vote to those who have committed a felon. Now, some people think, maybe even in this room, that we deny the right to vote for a lifetime after a person has been convicted of a felony and their sentence is completely done. That is not correct. We allow them to be restored to their right to vote when their sentence is fully commuted. There are states that don't give any right to allow them to vote. If they commit a felony when they're 21 years old and they're put away for a number of years, they go through a probationary period of time for the rest of their life, even though their sentence is commuted. In some states, they're not allowed to vote. So in the big spectrum of this public policy, Minnesota is in the middle. We're not the extreme. And I think in some cases the proponents have created the idea that we are the extreme example, and we are not. So Madam Chair, I place this before the body. I will stand for questions or comments, and I ask for a roll call vote.
Members, I'm hoping that you would vote red on the Limmer amendment for several reasons. Number one, there was a survey that was done, a national survey, but it was, 2002, I will say. It was a national opinion poll that showed that 60% of Americans surveyed supported restoring voting rights to parolees and probationers. That was done by a guy by the name of Jeff Manza, and the name of the piece was Public Attitudes Towards Felons in the United States. It's a public opinion. But let me say here, I know that Senator Limmer has talked a lot about victims. And I did mention earlier, and I'm not sure if Senator Limmer heard me, or if he was in the chamber, or if he was distracted, but victims have been talking about this restore the vote. In fact, I mentioned earlier that there's discussions with the Minnesota Alliance on Crime, which is a victims, for lack of a better word, organization. And I've also heard from victims who've come to me and said that it is their pleasure and their desire for anyone that has perpetrated a crime to be supported, to continue to maintain civility, not reoffend, and anything that leads them to that notion of not reoffending, and so no one has to experience what they have experienced in the past, that would be their desire. In fact, Senator Limmer knows that there's a young lady from his district who was a victim who also came and spoke to not only me, but to him. So this is not out of step with doing what's in the best interest of not just a felon, but we're talking about public safety. We're talking about how do we make sure that individuals are on the right pathway, but also making sure that they are not reoffending or encouraging anyone else to reoffend, so that we don't have victims. And in fact, victims have a right to speak because we have what they call victim impact whenever someone perpetrates a crime on someone. It is by law that victims have to be notified and come into court and talk to the court and talk to the alleged perpetrator. But by that time, that person would either be a defined perpetrator or not. We believe it's important for social activities to be embraced in order to lead to reintegration and causes us to refrain from committing crimes. That's important. And so when we couple that with our democracy, the tenets of our democracy, wanting to make sure that everyone has a right to vote, we should vote in support of restoring the vote, and therefore it would require you to vote red on Senator Limmer's amendment.
Further discussion on the 825 amendment, Senator Limmer.
Thank you, Madam President. Would Senator Champion yield for a question?
Senator Champion, do you yield? Yes, he does. Senator Limmer.
Thank you, Madam Chair. Senator Champion, I'm looking over the bill with your provision in it, and somehow I'm missing that part that said that the victims would be notified when a person who had been convicted of a crime was going to get his right to vote. Could you point that out to me in your bill?
Senator Champion.
Thank you, Madam President. Senator Limmer, it is not in this bill because it is a part of our existing law that if a person is a victim and when a alleged perpetrator goes through the process, if they are found guilty or if they plead guilty, the court cannot sentence that person until they get victim impact, a victim impact statement. Victims are engaged and victims are involved. And in fact, in every case where a victim has come in to talk about how they feel or what they would like to do, what they've always said is, I want to make sure that whatever the court sentences this person to do, that they are allowed to get back into society and do positive things so that they will not put anyone else in the position that I've found myself. So that's what this bill seeks to do. It seeks to say, what can we do to support someone who has paid their debt or who is out? And as Senator Sharon has said in the committee that I embrace, is that at sentencing is where there's a discussion around public safety and making sure that we concentrate on public safety. But once a person is out in the community, we should concentrate on reintegration and giving them the tools and the support that they need to continue to be law-abiding citizens. And that's what I believe is important, and I believe that's why we should vote red on Senator Limmer's amendment.
Further discussion, Senator Limmer.
Thank you, Madam President. Senator Champion, by your answer to me, you made reference to a victim impact statement. That happens at the time of sentencing, way at the very beginning of the inmate's journey into the correction system. It could be 10, 20 years. It could even be longer than that. That's when we get the victim impact statement. What about when that door of the correction facility opens up? Where is the victim? Where does it say that the victim will be informed of whether or not they have an opinion about how they were victimized and how they had to struggle with the loss over those many years as their offender that did the crime to them remained in a prison facility? It's not here. And I doubt very much that it would be real easy to find them either. You know, you're asking us to put our trust in an individual who broke the law, and now they want to have the right to vote to make law, to have someone represent them to make law. And somehow I find that incongruous. I find it to be rather unusual. You know, back before this country was ever formed, there was an English philosopher called John Locke. And John Locke was a very influential person. He influenced most of our Constitution. And he even made reference that anyone who committed a crime against another innocent citizen, that their voting rights could be taken away. This was before people of minorities had a vote. This was applied to those that did have the vote, and they were all white. So this is not a question of race, as some have said in this debate earlier today, but it's a question of the very formation of our nation allowed this. And it was, as John Locke said, there was a kind of a perpetual contract between individuals and their government, that individuals had to follow the law and that the government had to write law that was appropriate and not abusive. And as long as that was satisfied, John Locke said it was good government. And yet at the very same time, this is making quite a left turn away from that general philosophy that was the very beginning of our nation.
Further discussion, Senator Champion and then Senator Peterson. Senator Champion.
Thank you, Madam Chair, and I'll make it brief because I know that the hour is late. Senator Limmer, there's a couple things that I believe are important to say in response to what you have placed forward. Number one, you talk about the fact that we should, now we are asking, this bill is asking us as citizens to trust this person. What those individuals who are currently unable to vote is asking us to do, or in fact, they're asking us to trust them, but they want to trust us. They want to trust us to say that you really truly believe in second chance, that you're not just blowing smoke, you truly will demonstrate that you believe in second chances. And how is that done? In the event that a victim is further compromised, or if there's any concern, there's a no contact order. If a person violates any of their probationary conditions, there's a process in place that would handle that in real time. And an individual who commits, unfortunately, a crime, they don't stop living, Representative Limmer. They do not stop living. And in fact, we do not say to them, until you're able to vote, don't pay taxes. We expect them to pay taxes. We expect them to do everything every other citizen is doing, but we don't want them to vote. And that seems to be contrary to what I understand we really should want. We want people to have representation, especially if they are being taxed. We want them to have a say as to who should be on the school board if their children are going through any of our schools. We should want them to have a voice. That is at the basic level of our tendency. And last but certainly not least, Senator Limmer, you are now asking us to do something that the current law doesn't do. Right now, a person's right would be automatically restored, no matter how long or short. We don't have to send out any notice. In fact, the person doesn't have to come in and affirmatively ask for that right to be restored. But what I am truly saying is, this is an opportunity for us to give some individuals a second chance. This is an opportunity for us to decrease the number of victims who could potentially be perpetrated upon because they are involved in pro-social activities. This is an opportunity for children to see their parents vote. This is an opportunity for us in this chamber to do the right thing. Let's vote red on the Senator Limmer amendment, and let's go forward together. Thank you.
Madam President, members, I first want to call your attention and Senator Limmer's attention, particularly since he raised this question, to Minnesota Statute Section 611A.06, right to notice of release, subdivision 1. The Commissioner of Corrections or other custodial authorities shall make a good faith effort to notify the victim that the offender is to be released from imprisonment or incarceration, including release on extended furlough and for work release, release from a juvenile correctional facility, release from a facility in which the offender was confined due to incompetency, mental illness, or mental deficiency, etc. So there is specific statute that when an offender is released from custody, the victim is to be notified. At least the commissioner has to make a good faith effort to find the victim to notify them of that change in custody status. Secondly, members, with regard to the question of where were the victims at the Judiciary Committee, the fact is, like many groups, there are organizers, there are organizations, there are associations that are specifically centered on promoting and advocating for victim rights at the Capitol. They do pay attention to what's on the agenda. They do pay attention to the Judiciary Committee's work because this is where much of the victim-related legislation is heard. We did not have any organizations relating to victims' rights testifying against felony voting or the restoration of voting rights in this regard. None. In fact, members, if you look at the handout that is on your desk from the Republican Liberty Caucus, it indicates that there are going to be fewer victims because of the 30%, up to 30% reduction in crime from allowing released felons to vote, according to a study by the state of Florida in their state. And they specifically cite the problem of taxation without representation. If they're in the community paying taxes, they ought to be allowed to vote. Well, Senator Thompson, I think this is your opportunity to make your vote of conscience. You may not have a standalone bill brought before this body. So I think...
Senator Latz, it's really not allowed to address a member directly in the second person.
Understood, Madam President. I withdraw that comment. Madam President, this is Senator Thompson's opportunity to vote his conscience. He has stated for the record that he supports felony voting. Members, all of you, Madam President, this is all of the members' opportunity to vote their conscience on this question. It's a straight up or down vote on Article 4. I encourage you to vote against this amendment and thereby make an affirmative statement that we support the rights of those who are no longer incarcerated to participate fully in our society.
So, Madam President, I would like to thank Senator Latz for his ability to create a good seating arrangement in the Judiciary Committee. I get to meet Senator Champion, and I think we've developed a good friendship. We share many ideas. And the most important thing, it separates me from sitting next to Senator Hall, and that's vitally important. But I do believe that Senator Latz, you did adequately and accurately describe the procedure when an inmate leaves a prison facility. But the important distinction is this: notice, yes; statement of the victim, no. And that's a definite difference and a hallmark to where this particular page of legislation, if it was passed, is missing balance.
You were citing a study by the Republican Liberty Caucus or Liberty Committee, and I wanted to dive into it a little bit more. You indicated that the study showed felons that would be restored the right to vote would commit 30% less crimes. Did I understand that right?
Senator Latz?
Madam President, there's a handout on your desk, members, from the Republican Liberty Caucus of Minnesota and Liberty Minnesota PAC. And I will quote from their handout. I haven't independently verified anything that's in there. Those who get their voting rights restored are up to 30% less likely to commit crimes compared to those who remain disenfranchised, according to a Florida government analysis.
Senator Westrom?
Thank you, Madam President and Senator Latz. I guess probably the key word would be up to 30%. That could mean 1, it could be 10, it could be 15. I do find it hard to believe 30%, 1 out of 3 nearly, would have that as the exact reason that they didn't commit a crime, because all of those should have had voting rights before they ever committed a crime. And if voting is that important and much of a determinant of somebody not recommitting a crime, it's funny they would have committed a crime in the first place. So I would just be a little concerned that that's maybe a little misleading. But I do, with the words up to 30%, of course, we all know that doesn't mean 30%. So thank you, Madam President.
And I know that the members of the Judiciary Committee are aware that I've brought this up before, but when you take a look at criminal disenfranchisement laws across the United States, it might be of interest to you to know that there are some states that have no disenfranchisement for people with criminal convictions at all. So there is not necessarily an agreement in the United States that removing voters' rights has any relationship to what the consequences are that we place on a person for violating the law, no matter what level it is. But I do think I'd like to add to the conversation, since we've spent a lot of time on this, that there are a number of issues related to how we treat people that have committed crime. And whether or not there's credible evidence showing that continuing to disenfranchise people after release from prison serves any legitimate law enforcement purpose. So what is agreed upon as a typical points of criminal penalties? Why do we impose criminal penalties? And they are about 4 components. They might be articulated in different ways, but they typically are incapacitation from committing new crimes, a deterrence, retribution, which is what the victim's conversation has been about, whether or not the victims feel as though retribution has adequately been imposed, and rehabilitation. So the question really is, as I think Senator Peterson was saying, is that does post-incarceration disenfranchise do anything to further these goals? And there's been a number of studies to try to understand that. And what we have found, without stating all of those, that under incapacitation, which is about...
Excuse me, Senator Sharon. Senator Limmer, if you would mind taking your seat, you're standing in between the Speaker and the President.
Madam President, a point of order.
Senator Thompson.
Thank you, Madam President. And I am not directing this at Senator Sharon. I'm thinking about the entire conversation. We have an amendment in front of us to remove a provision of the omnibus bill that some of us believe should stand on its own. Again, no disrespect to Senator Sharon. I think in many ways, many people have gone way off topic. I raised the issue. I want to vote on the bill separately. That's all. That's what this amendment is about, and I would respectfully ask the President that we try to focus on that.
Senator Thompson had raised that issue with me privately. He does now publicly, and I will remind members that the issue before us is Senator Limmer's amendment to delete Article 4 from the bill. Senator Sharon, you may continue.
Well, I'm reflecting on Senator Thompson's request that we focus on the, if the question is whether or not we should address this as a sole bill on its own, that's one thing. But I understood that the amendment really deletes this concept altogether, and so I wanted to speak to the importance of retaining it in this bill, but wasn't really speaking to the component that Senator Thompson says about whether it should be going on its own. So I would like to just complete my comments, and that will not be endless. Just to make a point that
Senator Sharon,
that Senator Peterson really was focused on where I have been looking on this in judiciary was what is the public purpose, how does it relate to public safety, and there's those 4 areas. One is the incapacitation of committing new crimes, and the second is deterrence. The other is retribution, which has been some of the discussion around victims having something to say about what happens, and rehabilitation. And I'm just commenting that in each of those 4 areas, there really is nothing that has been indicated in the evidence that would suggest that withholding voter rights to persons after they've left jail and are in probation, anything that extends their disenfranchised does anything in any 4 of those areas. And in particular, in the area of retribution, the victims wanting retribution, what we're finding is that society recognizes that a punishment can be morally justified only as retribution if it is proportionate in its severity and duration to the crime in question. What we're finding is that disenfranchisement of people who have been released from prison is unjustifiably severe. To deny the vote to individuals who are out of prison and to disregard the assessment of the sentencing judge at that time and the correcting officials who have, with careful review, released a person from that jail, to not allow them to restore their voting rights and to fully participate in their communities is severe continuation of their punishment.
Senator Kiffmeyer.
Thank you, Madam President. Well, a very interesting discussion, and I appreciate, Madam President, everybody's comments. I did think, though, that as I was working this afternoon to do a little research, I was able to see some of the handouts ahead of time. Matter of fact, I have a handout myself that could go out. And in regards to, it's already up there. In regards to the situation here where we're using the state of Florida, I did a little research, Madam President, on what the states are about. And Florida is one of 11 states where you lose the right to vote permanently. And so I'm a little baffled by a quote that says that those who get their voting rights restored are up to 30% less likely to commit crimes compared to those who remain disenfranchised, according to a Florida government analysis. I was not able to find that Florida government analysis, Madam President, but I was able to find that in Florida, they do have the right on a lesser crime 5 years and a major crime 7 years to go before a clemency board. And so it's a very restricted situation. So the up to 30% in that context is very, very different from Minnesota. In Minnesota, we are one of 20 states that have this policy. Matter of fact, I found it quite interesting that when I took a look at not only Minnesota, but one article that I came across was Attorney General Eric Holder, who took the Minnesota current law position. We should restore the voting rights of all who have served their terms in prison or jail, completed their parole or probation, and paid their fines. Attorney General Eric Holder. And so I think, Madam President, in both clarifying the Florida situation helps put that statement in context, and then also adding another study to that. And so, Madam President, the situation here of the public purpose, what I found was very important is that there is a public purpose in probation and in parole. There is a public purpose. Madam President, we have people who have shown themselves to be irresponsible to one degree or another. Parole or probation allows them to be able to show themselves responsible, because the crimes that are committed are not just a violation of the person or the property, but also a violation in regards to society. And so the opportunity for folks to come to a position where they come back to society. That's why I was able to vote for Senator Newman's amendment, because it gave me that opportunity to recognize some of the comments that I've heard also, and yet the opportunity to see that public purpose. Certainly it is important for us to make sure that not all of these have just made a little mistake inadvertently. These are major things, and I thought that 2 years gave an opportunity for those who did make and give them that smaller mistake and give them an opportunity. So, Madam President, Minnesota current law is very much the majority of the country. I think it takes a reasonable process and gives them an opportunity to be restored. I think that's a very, very excellent way to do things, and certainly where the majority of our country is. And I would urge a yes vote on the 825 Limmer amendment. Thank you, Madam President.
Further discussion on the A25 amendment to delete Article 4. Senator Champion.
Thank you, Madam President. And last and certainly not least, when it comes to me standing up, I asked this body to oppose the Limmer amendment, but I wanted to make sure that we had some clarity as to this nexus between public safety and a person's right to vote, or restoring their right to vote. And the study that my Chair Latz was talking about is that there was a 2011 report by the Florida Patrol Commission, which is hardly a liberal group, I'll say that, found that ex-prisoners who had their voting rights restored had recidivism rates of 11% compared to 33% for those who did not have their rights restored. And so the public safety benefit of pro-social activities is a primary reason allowing those on community supervision to vote is supported also by the American Probation and Parole Association, because there is no evidence that when you deny someone the right to vote, that notion deters crime or lowers recidivism. So with that being said, I would hope that you would vote red on the Limmer Amendment.